Meeting. As you will no doubt be aware, the meeting concerns the called-in planning application in principle for mixed-use development, associated works, car parking, servicing, access, public realm, all at land near Eastfield Road in Edinburgh. My name is Keith Bray. I'm the reporter appointed by Scottish ministers to report back to them before they would make a decision on this application. So my job is to report back to ministers. I have a colleague here today, Ewan, at the back of the room. Ewan is operating the technology for the webcasting. We are being filmed today, recording and streaming live, I understand, today. That's all part of the DPA's strategy to enhance public access to planning and planning appeals and their processes. It should make it easier for individuals to keep up to date if they're not able to come along. I know that there are one or two who haven't been able to come along today. The webcast will be available on the DPA website for you to look at your leisure. We do tend to try and record as many hearings and inquiries as is possible. Today the camera will be directed at myself and the participants around the table. So anyone in the public seats, I'm assured that the camera doesn't actually catch you out, so you'll be happy with that. Are there any questions about filming? Occasionally it is sensitive. Everyone content? That's good. We'll move on to housekeeping. Mobile phones, switch off or silent, please. Event of a fire. Fire exit to my left. Straight out the door, round the building to my right, and assemble at the green area outside the hotel. There are no planned fire drills that I've been made aware of. I don't plan to take a break, but if you do need the facilities, there are toilets just out in the corridor. If anyone feels that there is a need for a break, if we are going on a little bit longer than a couple of hours, then I can certainly take a break, and we'll discuss that as we go through the agenda. I'll shortly ask you all to introduce yourselves, and there's an attendance list, I think, going round. I saw it at the back earlier on. It should be moving its way round. Just remind me to take that away, or to remind you to take that away before we go, so we know who was here. So, clockwise to my left.
Thank you, sir. I'm Neil Collar, a solicitor. I'm here representing the applicant. I'm accompanied to my left by Mr. Rob Newton and then by Mr. Douglas Bissett.
I'm Alan Farker. I'm the Planning, Advice and Engagement Manager for Scottish Environment Protection Agency, SEPA.
Good afternoon, sir. My name is Alistair McKee. I'm a solicitor with the law firm Anderson Strathern. I'm representing Edinburgh Airport Limited, who are one of the principal objectors to this application. On my left is Stephen Swan, who is the legal director at the airport. And on my right is Ian Lang, who is a capital director.
Good afternoon. My name is Graham Nelson. I'm a solicitor for the council. On my left is Elaine Campbell, team manager from planning, and on my right is Francis Newton, senior planner.
Okay, thank you all for that. That concludes item 1. So moving on to item 2, which is the reason for the called-in application. That's on the agenda simply to be sure that everyone understands the terms of the call-in. Was to allow further consideration of transport impacts of the proposed development in view of its national importance, in particular the West Edinburgh area. Now, can I just check that everyone has seen that letter? Everyone is content that they know that letter exists. Everyone's nodding, so that's good. One matter I would like to point out is that although the reason for the called-in matter relates to transport, I need to report back to ministers on all matters with regard to the application so that I can make a comprehensive recommendation to ministers. So I will cover all aspects of the development, not only the matters that will be subject to further procedure, for example, subjects that may be discussed at hearings. Is there any questions on the nature of the report and how I'll be reporting back to ministers? Are we all quite clear on that? Quite clear. Thank you. So that's item 2 dispensed with. Item 3, the purpose of this meeting. And for many, this will be familiar, but the purpose is to discuss the arrangements and procedures to be followed. It's not a hearing, and it's not for the discussion or presentation of evidence on the merits of the proposal. We always emphasise that. We will seek to agree collectively how the called-in application should be taken forward. If there are any elements of discussion that there is not a conclusion today, I will take that away and come to a conclusion in my note of the meeting, which will be circulated. I have noted that both Edinburgh Airport and a response from the applicant has been submitted since the agenda has gone out, and I do plan to briefly touch on the matter of a request for a transport assessment under item 7 of the agenda, and that's been communicated to the parties. So I trust we're all clear on what we're here to do today. It's to talk about the procedures and not the merits of the case. Okay, thank you. Moving on to item 4, just to make sure everyone's content and understand the context within which the proceedings will follow. The appeals regulations, 2013 regulations, set out how appeals are to be determined, and that includes hearing session rules, which many of you will be familiar with. The rules and regulations allow procedures to be tailored to the particular case, which means that any procedures that will be agreed in our note of the meeting and any subsequent procedures are only those that are required on specific topics. They tend to be inquiries, which is giving of evidence and cross-examining, which I'm at the moment not proposing. Informal hearings, where I chair proceedings in a round-table discussion and we go through the issues involved, but I lead that discussion through an agenda. Further written submissions, where specific parties are asked to provide information, provide documentation, or clarify their evidence, and everyone else gets an opportunity to contribute to those responses as well. Or there's no further procedure. So if it's my conclusion that I have enough information on certain subjects, then there would be no further procedure. So that's what the options are. As you may know, Section 24 of the regulations allow those procedures to be implemented for called-in applications that have been called in by ministers. So I just want to check that everyone is content, that they are aware that we will be conducting proceedings under those regulations in the hearing session rules. I'm seeing nods from all around the room. It's also my understanding that the application was submitted in December 2015, and that has implications for EIA regs, and in terms of the EIA regs, it would be considered under the 2011 regs because it was submitted before. Is there any disagreement on that, or can we proceed on that basis? Okay, everyone's agreed on that. So that's item 4. Dispense with. You will all get a chance to contribute at some point during the meeting, don't worry. Item 5 was just an opportunity for any of the parties to clarify anything that's happened since the call-in has been issued, or clarify anything that's missing, perhaps, that's been submitted to the DPA. Again, it's not an opportunity to discuss the evidence that's there, but one matter that I have become aware of is that Transport Scotland, as I understand it from our case officer, were consulted but did not respond and I think that's been checked out with Edinburgh Council, and that is why you will have seen a further information request from Transport Scotland in my list of provisional further information requests. So that's the one matter that I wanted to put on record in terms of this meeting. Is there anything else that I should be made aware of in terms of any updates or specific clarifications since the application has been called in? Is there anything glaringly missing from our website, for example? Or are we all content that we're proceeding with all the information thus far that we should have?
Just one point in relation to the SUDs on the site. I understand that a SUDs pond relating to the Park and Ride site has been filled in as part of works undertaken on behalf of the council.
Okay. And that refers to one of the matters which is set out on, I think, in my further information.
There is that relationship, yes.
Request. So that may well be, once we come to that point, that I still ask for that because I have read about it, but it might be a short response that you provide. But I think I would still ask for the information. Okay. And we'll discuss that further on down the agenda. So we're all content.
Sir, before we move forward, I would like to check to make sure that all of the responses from Edinburgh Airport Limited to the council in view of the application are actually on your website, because I haven't undertaken that, or I haven't checked them anyway.
Well, if you do have any problems with what's there, please contact our case officer, and those will be updated. I don't think I'll record it in the minute, but I don't think there's anything else required. So we'll move on to item 6, which is the provisional assessment of the main topics that require further procedure. Those are not my assessment of the main topics for the application. Those are those which are considered to need further procedure. The first page of Appendix A relates to further written submissions. And the second page indicates a range of topics to cover through hearings. At this point, item 6 on the agenda, I just simply want to ask, are there areas which have been omitted or areas that can be deleted through agreement or dealt with in a different way in terms of the procedure that we have before us today in terms of my provisional assessment? There was a request for clarification on a couple of the bullet points, I think both by SEPA and by the applicant, and I'll do so once we go through the agenda. I will come to those bullet points. So the key question just now is to make sure that everyone is content with those lists. Is there anything that is missing? Is there anything that needs to be added? One matter that I was going to raise was the West Edinburgh Planning Framework. I put that on because it's been mentioned. Obviously, it's historical now. If there was agreement that I didn't need to see that, then I'd be quite happy. But it's on that list because it has been referenced, but I do know it's not current at the moment. So for context, I was going to have a look at it. But if there's broad agreement that there's no need to look at that, then I can take that on board. But other than that, is there anything else?
Sorry, if I could maybe kick off on behalf of the applicant. There wasn't anything that we felt could be omitted, but hearing what you were just saying about the West Edinburgh Planning Framework, certainly we would be content if you felt it didn't require further discussion for that to be taken off the agenda, as it were. There wasn't anything that we felt there was a pressing need to add in, and as you say, it would be useful to get some clarifications, but happy that, as you said, that will be dealt with in due course.
Perhaps if I turn to the Council and just, would you agree with not needing to see the context, or would it be useful for me?
reasonably neutral on that point in terms of it's fine if you want to see it for context, but certainly I'm not expecting it's something we're going to need to go into depth or give written submission on to you. We're certainly more than happy to lodge a copy with you so you have it, and if you need it for context, then fine. But equally, there's no burning desire from our point of view that it needs to be lodged with you. I'm presuming from your, just for clarification on your further written submissions, that where it's just documents you're specifying, it's just you're wanting those documents submitted by a set deadline. Normally we'll talk about the deadline in due course, but unless it's actually a specific request, it's just the documents you're asking for. Yeah.
That's correct. That's correct.
Sir, if I could respond on the West Edinburgh Planning Framework, the Edinburgh Airport thinks it is important that that's provided by way of context, and in that way we'd like to be associated with the Council's position on that. It provides important background to the policies.
Well, based on what I've heard, I think, and it was my original conclusion that for context, and if there is an electronic copy around, then I'm more than happy to have that. But I do understand that it's not current and it is simply context. It's been referenced in a number of the documents. Okay, thank you. Anything else on the provisional list before we go into the detail of it? Is there anything that is omitted? No? Okay. So item 7 deals with the topics and documents for further written submissions. Now, before I go on to that list, the correspondence that I've seen that's been sent into our department from the airport and the response that was provided by the applicant, if everyone's content, I would like everyone to have an opportunity just to comment back on that. Those two documents, I think they've been circulated, but as part of further written submissions, I would simply give everyone the opportunity to respond to the email from the airport and the correspondence, the letter that came in advance of this proceeding, simply to allow all the parties to make comments if they wish. So I would add that to my list of further written submissions, just to ensure that everyone has had the opportunity to comment. It's a fairly minor point, but I just wanted to make sure that everyone was content that I add those two pieces of correspondence to a list, and probably to respond to that at the last deadline that we'll talk about in terms of further written submissions.
Sir, could I just come back to you on that? I was rather hoping that we could maybe discuss the merits or demerits, as others may have the view, of our sort of pause and collaborate proposal round the table today, rather than sort of go away and think about it and respond, because obviously Mr. Collars had a chance to respond in writing. The Council has seen my email of the 28th of November, and I was really proposing just to sort of set out the justification for that for you and for the parties here, and have a general discussion as to whether or not it's considered to have merit, because it is quite a fundamental thing we are suggesting. It's a change in direction.
Well, as outlined at the start, this meeting is not the place really to discuss the merits of individual parties' cases. But what I was going to say, and I'll say it now, is that my job is to have enough information to explain the different positions of all the parties to ministers, and request information, hold hearings, to ensure that I have enough information to report back clearly on the positions of each party, and have enough information to make a recommendation. I need to receive the information that I would request, hold the hearings, test the positions through questioning of the parties, and I would anticipate that my conclusion on that matter would be in my report to ministers. That's where I would reach my conclusion on that matter. If there was clear consensus that a piece of evidence was missing, and all parties were agreed that a critical piece of evidence is missing in a case, then I could see a reason for asking for that additional information. What I need to do is explain each individual's position. The council have a position, the airport will have a position, and the applicant have a position. So I need to understand that, have enough information to understand that, and then report that back to ministers and come to my conclusion. What I would say and assure you that the fact that I've not said we would discuss it in detail today, it is on the hearing bullet point list to discuss the matter of the need for a transport assessment. That doesn't indicate in any way a conclusion that I have drawn on the matter one way or other. But what I need to do is to understand everyone's position and report that back to the Minister and then come to my conclusion. Does that
I certainly understand your position, sir. I just thought there was some, there was an advantage in resolving the matter sooner rather than later, rather than, say, for example, you having to decide whether the amalgam of transport information that's been provided by the applicant amounts to a compliant transport assessment. That's obviously going to be one of your jobs here. We'll be saying it doesn't, but be that as it may, would it not be an efficiency for the applicant to go ahead and actually do something which was a compliant transport assessment, and then we can have a look at that. That's where we're coming from, and that will be our stance at in the hearings and documentation going forward.
I understand that point, but I obviously understand that other parties have got different positions, and I don't want to reiterate that my job is not to sort of my job is to just look at the parties' positions, have enough information on those positions in order that I make a clear recommendation. Based on the information that comes back and the outcome of the hearing, that doesn't preclude further procedure. That would be a matter that I could consider, but I would anticipate making that conclusion in my report to ministers. Thank you. My assessment at the moment, and I would seek your agreement, is that the further information listed wouldn't constitute additional information or supplementary environmental information in terms of the EIA regulations. And I just want to make sure that everyone was content with that.
The airport are content, sir.
Okay. Thank you all. Now we're on to dates. In terms of response dates, draft initial response dates, I would intend to issue the note of the meeting early next week, and I proposed a response date for further written submissions on the 10th of January. That's a bit longer than normal, but there is a festive period coming up, and then followed by that would be the opportunity for those to make comments on those submissions, and that would be the 27th of January. I just want to be sure that everyone is content with those timescales, given it is falling over the Christmas period. Perhaps I'll go round the table on this one, and we'll start with the applicant.
Thank you, sir. The applicant's content, but I appreciate that the bulk of the work would really seem to be on the council. The only observation I might make, but I don't have a settled view on it, is whether there might be scope to align some of these deadlines with the preparation and disclosure deadlines for the hearings, because I didn't actually do the maths on this, but it seemed that the deadlines might not align and it might just get a bit confusing. As I say, I don't have a settled view on that. It's really just an observation.
Just on that point, though, when we come on to talk about prior disclosure, I was keen that a deadline for example, for submitting hearing statements was after all the written submissions had been concluded. So that was my reasoning around that. From SEPA's perspective,
I don't have any comment on the deadlines, but in terms of the information, the third bullet point asks about the air quality information. I would say that it's the local authority that should be providing that information, as they're the lead authority on air quality. They declare air quality management areas and manage and monitor those areas, although there is consultation with SEPA as part of that, but they are the lead authority.
Council content with that?
I think I just missed what is suggested there. Sorry.
For the air quality information that's set out in bullet point 3, that should be provided by the local authority as the lead authority for air quality.
Agreed, yeah.
Okay. And the airport, in terms of the timescales proposed?
The timescales are fine, sir. I did have a comment about the identification of what the airport have to give their updated position upon. You say that they have to give their current position in the light of the applicant's transport position paper, comma, technical note. And I just wanted to be crystal clear what those two documents were. It may be that the applicants can help us on that, sir.
This was based on my understanding when your last submission on the application was. May have been after, obviously, the council had considered it. So in terms of the committee report and the submission of the two papers that I've highlighted. So I wanted to be sure that I had your position on all the information essentially that the council had before it and on the council's committee report. And I can be specific in the note of my meeting, giving dates and such like of the papers. But I just maybe like the applicant to come in here.
Maybe just because Mr. Collar has actually submitted, as part of his response to my email of the 28th, a list of what the updated transport documents are. And I just couldn't see a thing called the transport position paper. I was just, maybe it's getting called something different. So I'll just go and get that out of my folder just now.
Sir, I would prefer not to get into a discussion because I fear I would probably confuse things more because I take Mr McKee's point that it's the correct name of the documents that he's looking for clarity on. So it's perhaps something that might be better followed up after this meeting rather than us getting more confused in trying to clarify matters.
What I'll undertake to do, that's obviously a series of bullet points, is to clarify the names as I understand it and the dates of the papers. My key objective was to be sure that I had your position based on the council's consideration of it and the latter transportation papers that were submitted. I don't know if the council want to say anything at this point.
Sorry, I was going to comment back on the dates point. I think, as Mr Collar touched upon, there is quite a substantive amount for the council to pull together there between different members and different officers within the council. And with, I suppose, with the festive period, then a lot of them, in terms of availability, it probably is only the week of the 6th. I'm starting to be able to coordinate stuff with them. So if it was at all possible to be the 17th rather than the 10th for the initial submissions, that would be exceedingly helpful in terms of us just ensuring we got all that to you on the deadline and everyone had an adequate period after it to respond.
Yeah, and just maybe in clarification in and around that discussion about without trying to add further confusion, I think the transportation position paper, should be dash technical note, was one document that was submitted as part of the application, just in terms of the Edinburgh Airport clarification position. I think you've got transport position paper, comma. I think it's there's one document there which is the common thread across those. And then in terms of the applicant's submission, in terms of clarifying documents, plans for approval, I think we would probably work with the applicant just to confirm what we had recorded in terms of the committee report, in terms of what we had suggested for approval as well.
I think on that, what I would do, would ask, because I think the applicant had a list of plans for approval set out in their planning statement. I'd like to get clarity on that, and then the council would obviously have the ability to comment back on that once that was submitted.
We have no difficulty if the date is going to be put back a bit, as suggested by the Council, but I do think it's absolutely definitive that we need to have knowledge of what are the documents which we need to make our submission upon. Well, it needs to be crystal clear.
If we are to move the date, it probably has a knock-on effect on some of the other dates that we discuss, but I don't really want to push hard on the 10th of January given the time of year. So if everyone's content with the 17th of January for submissions, initial submissions that is. Okay. The 27th of January, would we push that back by a week? Does anyone have any view on that? The Council, perhaps?
I think that would be reasonable, since we, I suppose some of the submissions on that first round could be substantive, and not least, I suppose, this issue of the transport assessment and people's further submissions on that, and concluding submissions on that point. To allow 2 weeks would be sensible.
So, are we content that that would be the 3rd of February then? I was just checking that. 3rd of February for everyone? Thank you. And my final point on this matter is that if, for any reason, there is a need to include some of those topics in the hearing, if I'm not clear on what's in the documents and such like, then there is the possibility that some of these matters that aren't listed to be discussed at the hearing could be. I don't anticipate that, but because most of it is documentation, just so I have the documentation. Because this is a called-in application and not like a normal appeal, we don't have all of the information, and that's why there's a fairly long list for the Council to provide.
And sorry. So presumably, if that's the case, you'll issue a note after those initial submissions to clarify that, so that the hearing statements can reflect it in terms of parties' topics, what we cover in our hearing statements.
Yes, if there's any change, we would certainly intimate that. Okay, that I think covers off item 7 in terms of discussing the topics for further written submissions.
So just before we go on there, could we just have a date for when the airport are going to be? It's going to be confirmed to the airport what all the documents are that we need to make a statement on. Is that going to come from the applicants or from the Council?
No,
and if so, when?
That will come in my note of this meeting. My note will essentially be a procedure notice. It will document, not verbatim what we've discussed, but the key agreed points, and it will act as a procedure notice. So it will be more detailed and set out timetables, and will be in a different format in terms of rather than bullet points. And that, as I said, should be issued early next week. Now on to item 8, which is hearings, to discuss the hearing topics and participation at the hearings. I've illustrated earlier on that hearings would be a structured discussion between the parties. I'll try and lead those discussions. There'll be a more detailed agenda, but no cross-examination. The list of topics to help frame any hearing statements is provided in Appendix A, and after this discussion, I would seek to clarify all these points in the note of this meeting, if there are any matters that need to be clarified. Essentially, what I'm proposing are 3 hearings, one on policy matters, one on transportation, related matters and on planning conditions and legal agreements. It's important to point out at this point, simply because there is a proposal to have a hearing on conditions and legal agreement, that's no indication of my thinking or anyone else's thinking on the application. Our reports to ministers on called-in cases and report cases have to be comprehensive, and regardless of our recommendations that we make, we have to provide conditions to ministers should they be minded to grant consent to any case, regardless of the recommendations that are made by reporters. So that's why there is a reason to go into the detail. It's not because there is any conclusion drawn at this moment in time, and I think it's important that we all hear that. There was a couple of matters that I think there was a little bit more explanation required in relation to air quality. I think SEPA had mentioned it's a little bit sort of vague, and also I think it was mentioned by the applicant in particular, some more clarification on that. So my key questions for the hearing will be around the impact of the proposal on air quality, and in particular on air management areas nearby, of which I understand there are two, one a little bit nearer, and to discuss the delivery of measures identified as mitigation. So that's what I would seek to discuss, and I'll cover that and include that in my note of this meeting. Also, there was a clarification sought in the letter from the applicant on master planning in the policy hearing, session 1. What is meant by that is policy requirements for master planning rather than master planning per se, and the detail of it. It's really the policy, the broad policy requirements set out by the planning framework for this application. Does that clarify the points for the applicant?
It does, sir. I think to reflect it back to you by way of illustration, what I would take from that is that on master planning, the best person to address you on that would be the planning consultant who's addressing the planning policies in general, and on air quality, it sounds as though it would be appropriate to have someone with the expertise in air quality rather than necessarily the transportation person, but it's clearly something we would need to discuss through. But does that sort of reflect your feeling and how it would be approached at the hearing?
I would certainly say that sounds to be a fair sort of assessment. Are there any other comments on matters to be discussed at the hearings? Bearing in mind that the agenda for the hearing will be a little bit more pointed, and that there may be questions so that everyone's clear in what we'll discuss. Having read all the hearing statements, are we all quite clear that this is a broad list of topics that will be honed down into agenda points once the statements are with us? Okay. On the matter of closing submissions, I don't, at this moment in time, anticipate the need for closing submissions at the end of all the hearings or individual hearings, but I would really like to hear your views on that, if you feel that there may be a need for closing submissions, either a written timetable or preferably oral at the hearings, or if you agree that you don't see a need at this moment in time for closing submissions. And again, if I start with the applicant.
Thank you, sir. I don't have a clear view at this stage, and at the risk of putting things off, perhaps it's something that we could revisit at the hearings themselves. For instance, the hearing session on transportation, we're predicting a day. It may be that we cover so much ground in that day that we would agree that closing submissions would be useful. On the other hand, we might actually finish that day with a feeling of clarity and feel that closing submissions would be a bit superfluous. So maybe suggest we could just reserve our position and revisit it when we actually do the hearings.
People do any position on that?
No view, no.
The airport wish to have a similar position as Mr Collar. We'd like to see how it goes on the day. There may be a particular issue in which we do want to make further written submissions, and they may be helpful for you in your decision making. But until we reach that point, I think it's quite hard to make a hard and firm judgment.
Thank you. The Council.
I basically share Mr Collar's view. I have no real difficulty if you're wishing to schedule a time for a written submission or something provisionally, fine, but we could leave it open of whether that's truly necessary by the end of the hearing sessions to actually proceed with that, or whether you have sufficient before you. Certainly not thinking that any such closing submissions would be on anything other than the hearing topics. I understand that's what you're wanting.
I think based on the discussion with your agreement, I will allow a point on the agenda for closing submissions on each hearing. So at least it's on the agenda for oral submissions, and if there is a pressing need, or I come to the conclusion that there is a need for written submissions with a timetable afterwards, then I'd be happy to deal with that at the hearings. But I think to timetable in the hearings a slot after a break perhaps for any closing submissions on the topics that we've discussed at each of the hearings. Does that sound like a reasonable proposal? Yes. Thank you all. The note of the meeting will highlight, obviously, that Transport Scotland will be asked to provide further written reps on their view on the application, and I would anticipate that Transport Scotland would become a party if they choose to respond, that is, and would therefore be able to contribute to a hearing. But that is really dependent upon a response to the further information. So I will record that in the minute that we would anticipate Transport Scotland becoming a party to the hearing. But until we get a response back, because at the moment they didn't respond, so therefore technically at the moment not quite a party. So I will record that in the note. I have estimated a time for the hearing. We've touched on that earlier on. I would like to build in a little bit of flexibility around that. A day for transport-related matters, including air quality. Essentially half a day, 3 hours for policy, and the same for conditions and legal agreements. But I would like to build in a bit of flexibility, so that is why I have identified 3 days to provide a little bit of to be able to cope with overrun. But do those estimates, because that's all they are at the moment, do those estimates seem reasonable to all the parties at the moment?
I think in terms of the session 1 and session 3, half a day for each of those, certainly, sir. Allowing that sort of time frame of a day overrun seems not unreasonable for the hearing session 2, especially if Transport Scotland are also taking part. That could be a fairly substantive session, I think, in terms of time. All I'm raising now in terms of that as a possibility is whether you're scheduling it as 4 rather than 3 days in total, and if that means that it ends up being a site visit accompanied or otherwise, we'll get on site visits as part of that time, then that can happen, but it just would seem better that than ending up us not quite getting through everything by the end of the 3rd day.
Well, perhaps we'll come back to that when we discuss the programming, but does anyone any concerns that I'm overestimating I don't think that there seems to be anyone saying that. The key thing is to build in the capacity for a bit of overrun, and we'll discuss that during our discussion on programming and dates. Okay, I think we can move on to item 9 now in terms of dates. I had provisionally...
Sorry, can I just go back? Did we actually confirm who is all taking part in each of the hearings? I don't know if I actually had that noted, because the airport would like to take part at the moment in all of the hearings.
Yes,
so
I'd assumed that all the parties
right,
here, but
right.
let's just check. Council?
Yes, all sessions for us, sir.
Yeah, and for the airport, all sessions.
That's correct, sir. And the airport will have with them probably a planning consultant, but definitely a transport engineer. So.
Thank you. And for SIPA?
Only the second session.
Second session.
Yeah.
All the sessions.
Yeah. Thank you for that. I think we can move on now in terms of the date. I had indicated the week beginning the 24th of February. We have discussed putting back the date of the written submissions. Was everyone available on the week beginning the 24th of February, first of all, while I get my calendar out? For the Council?
With the exception of the 24th, which is the Monday, so we are available.
Council?
Yeah, but date-wise, then yes, that week's available.
The applicant?
Yes, sir.
Well, for the moment, if we can agree that date, when we discuss the timetable for disclosure of cases, we might revisit that, but hopefully we can stick to that date, given that that was the indicative week. Are we okay to go Tuesday, Wednesday, Thursday?
That's fine, sir, because Monday's out for me, unfortunately.
In terms of Monday's out? All happy with that? The Tuesday, Wednesday, Thursday of that week? So hearing statements, I would propose that each party is given the opportunity to prepare a statement. For policy, is really looking at which planning policies are current and relevant, their interpretation relevant to the case, and your broad assessment, which many of you will be used to preparing. Is there any scope for agreed statements with regard to policy matters between all parties, between one or two parties? But I just wanted to discuss the opportunity for any agreed statements so that we can really focus down on the areas of concern. Perhaps I could ask the applicant first.
Sir, the written submission exchange might actually perform that function, that the Council provide a statement on the policy context and the other parties have an opportunity to respond to that. So that would be the opportunity for us to indicate which aspects were agreed. So it might not necessarily take the form of a statement, perhaps more of an exchange, but identify the areas of agreement as part of that.
And the Council?
Sorry, I suppose on that first point, no, I don't think we were certainly taking it as that we were providing any sort of statement on those policies. It was that we were providing the policies, those documents to you in terms of that initial further written submissions. There were specific aspects we'd been asked to clarify and explain, which we would do. But I don't think in terms of that initial clarification of the Council's position, that's coming from that step at least, sir, at least as it stands.
No, I wouldn't be asking for that. If you chose to do that, that would be a separate matter. But in terms of the documentation, it's just simply that is listed. But the question is really whether there is merit in preparing joint statements between all parties or between one or two parties on policy matters, in order that I can focus my attention on the matters in dispute. If the timescales and content of responses don't allow for that, then I'm quite happy to leave it open that it's between the parties if they wanted to prepare a joint statement. I wouldn't be insisting on a joint statement, but I would, in my note of the meeting, I might just leave the opportunity there for the parties to prepare a joint statement on policy matters if they think it's reasonable in terms of focusing the attention of the hearing, the Council.
Yes, sir. I think that's a perfectly a reasonable, fair way forward with it, in that certainly as it stands, I'm sure we'll go on to the dates for the hearing statements and so on, but it seems as if we're on the 3rd and then the 7th or something for the two respective deadlines for the last of the written submissions, and then hearing statements. And even if that's slightly later, then in terms of what stems or flows from that initial assessment and how that affects any agreement, it may make it quite difficult to have a statement of agreement between parties. It's not to say we won't try, but in terms of committing to that, I think that would be difficult to say for certain that we can get that to you.
So if I can maybe assist, as parties will know, the airport does not object to the principle of this development. It is identified as national development in the national planning framework and the development plan. The airport's sole concern is in relation to the potential for adverse traffic impacts. That having been said, I think that probably does narrow down quite a lot of areas where we are in agreement and not in agreement. And whilst I don't think we're in a position to sort of, have a formal statement of agreed matters, that what I've just described is clearly our terms of reference for all of these 3 hearings, which I think does narrow down matters quite a lot, sir, Yeah. Because there are certain elements within the hearings which, for example, air quality, I know it impinges upon transportation, but probably wouldn't be a fundamental issue for the airport, as you might understand.
Well, I think if everyone has agreed, what I will do in the note is leave the opportunity, if there is agreement between the parties separately, to submit statements. But I do understand, and I'll take the point of the Council, that time scales might be tight to gather that together. And the point made by the airport is that it may well be quite clear where the disputes are, even from the submissions already. So I'll just leave it open so that the parties are invited, if they wish, to submit statements.
One further point from that, sir, or maybe slightly off it, but was in terms of hearing session 1 especially, and policy, was maybe just for when it's for clarification in your note or otherwise, of where it's these policies and you're just looking at it from the transport perspective, and that's what you're looking for submission from the parties for the hearing. It'd be helpful for that to be stated if you're wanting more broad statements on that policy or documents for the application. Then fine, but I suppose that would implicate how long and how detailed that might be. Again, if you're wanting that covered off, much of that may be an agreement, and it may just be the transport aspect that we are focusing in on in terms of point of disagreement for that. It's just from the hearing session agenda as it stands, a lot of those are the very broad document and submission on them, rather than it being as focused as that.
My intention would be that the policy hearing is broad, and that it looks across the policy framework that's relevant to this application, and your interpretation of the key policies and any assessment. Bearing in mind, as I set out at the start, my role is to report back comprehensively to ministers. So I just want to be clear in everyone's position on policy matters. So that policy session would be a broader policy assessment. I know that all parties may not have an interest in all the policies, but I would anticipate that some of the parties are quite keen to go through to make sure that all the policies are covered off and I would certainly want to see where the areas of dispute are, and it's likely the second hearing is going to discuss that matter in more detail. But it's just useful to go through the broad policy context, given that my report has to be comprehensive.
Thank you for the clarification, sir. I'm sure our hearing statements will be able to focus that a lot more in terms of giving the detailed position of each party on that.
In terms of conditions and legal agreements, are we in the same position in that if there is an opportunity between parties, potentially this is between the council and the applicant, but it could include others in terms of agreeing conditions that are agreed, it's usually between the local authority and the applicant, and any areas where there are dispute or where there is dispute, would you think there is scope for the conditions hearing for matters that are agreed? That might actually save some work for the parties.
Yes, in terms of conditions and heads of terms for legal agreement, there should be good scope for getting that firmed up. I think a lot of that work had already been done in this case.
And the applicant?
I would agree, sir. The first step would perhaps be if the council at some point following on from today could confirm if they were going to change at all the conditions that were attached to the existing minded grant decision, and that confirmation, the applicant could then use that as the base to indicate areas of agreement and disagreement and progress it thereafter.
Does the airport want to mention anything at this point with regard to conditions and what could be collectively put together in terms of agreed statements? Or are you happy that that's left between the council and the applicant?
Obviously, what planning conditions or planning obligations rise in relation to transport mitigation is something which the airport does have an interest in, sir. So I think the airport would wish to be involved in the circulation of suggested conditions or heads of terms for Section 75 agreement. Whether we'd have quite level of involvement remains to be seen, sir, but we certainly want to be in the loop on that and be able to make comment if required.
Okay, so we've broad agreement, the hearing statements to be prepared, and there is the potential for agreement state matters, agreed matters specifically for conditions and a legal agreement. There may be an opportunity in policy matters, and that all parties would be asked to prepare hearing statements. Obviously, you don't need to cover all the matters. It's the matters that you're interested in, but I think it would be useful to hear everyone's views on these matters, and we need to discuss then the timescales for submitting that. I had in my mind a provisional date of the 7th of February, which is only a few days after the submission of final written submissions, but that would allow us, if you like, to go to hearing on the week commencing the 24th of February. Does that still seem reasonable? The applicant seems happy enough with that.
In principle, yes, sir. I'm just wondering, though, maybe to give a little bit more flexibility, even moving it to Monday the 10th would give, well, certainly 2 business days. I'm always slightly wary of deadlines, that if people miss the deadlines, then that can throw everyone's preparations if they've got meetings timetabled.
So we have a proposal for the 10th.
That's fine with the airport, sir.
Yeah. And with the council?
Certainly, moving it to the 10th would help a bit in terms of at least having the time to reflects on whatever's come in and finalised. I mean, I imagine for all parties we'll be preparing our statements whilst the rest of it's going on, and then finalising off the back of those further submissions on the 3rd. But yeah, the 10th should work okay.
Okay, so everyone's agreed the 10th for hearing statements. We will I'll endeavour to make sure the agenda is prepared at least 10 days before the hearing, ideally 2 weeks. But obviously with the 10th being the submission of the documents, then that is again reasonably tight, but I think we should try and achieve that if possible, to keep this moving forward. It's in everyone's interest that we do things efficiently. So long as 10 days in advance of the hearings you're happy with that for the circulation of the agendas. Applicant.
Yes, sir. If I could put in a request in terms of the agenda, having been involved in hearings before, I've certainly found it helpful if the agenda can indicate the questions you would like to discuss rather than using broad headings. It's just the more notice, the more detailed notice we can get, the easier it is for us preparing.
Yes, and I think I indicated earlier on that the agenda would be more focused and may include a number of questions, not necessarily exclusively questions, but likely to have a number of questions to allow all the parties to be fairly focused and know what is to be discussed. But if everyone's happy with 10 days in advance of the hearings for the agenda, and the agenda to be as tight as possible in terms of describing what is to be discussed, then it looks as if that's agreed. Councillor.
No difficulty with the dates, sir. I mean, I know you've said that agenda should have been before this, and you'll be focusing it further, obviously, by that point in giving us a final version. It really just, in terms of preparing hearing statements for everyone, if you're any further forward after this of having a bit more detail in it of a draft that we'd then be able to address for our hearing statements to give you more focus it more in terms of issues you'd like, then that would indeed be helpful in advance of the hearing statement submission, and then to be finalised after you've seen everyone's hearing statements.
What I would plan to do is and the plan is after this meeting to look at those bullets again after our discussion, and have a quick look at some of the evidence again, and in the note of the meeting to be issued next week to provide a little bit more clarity. I think I said that earlier on. The note of the meeting will help sort of clarify that. It'll be slightly more expansive than the bullet points that are before you. And there's discussion that we're having as a help to me in order to do that. So hopefully in that note, which will double up as a procedure notice, you'll get a little bit more clarity in terms of the bullet points, in terms of what we'll be looking for at the hearings. So we have the 10th. The other matter that I was going to raise was actually that it'll be in a logical sequence. The bullets just now are fairly generic in terms of how they're sequenced. In my note of the meeting, and certainly in the agenda, it'll be a bit more structured in terms of how they flow from each other. So they might be in a slightly different order come the meeting note and the agenda. Okay, item 11, which is...
So I keep on saying, can we go back a little bit? Who is going to be doing the core documents? Normally that would be the council in this case, but and also what's the procedure for other documents?
We can deal with that just now. Core document normally for the council to at least keep the documents and have them available although it's a called-in application. I assume, unless you're advising otherwise, that would be in an office, in one of your planning offices, rather than a place locally that could be accessed. But in terms of keeping all the documents together, I'll come on to the core document list in a minute. But in terms of being the point of contact to access any information for a member of the public, would we just use your office that's on your correspondence, or?
Yes, we'll gather the physical sets where we can have a look at what the most local office is to the site in terms of actually having it on display for reasonable hours. I'm not sure. I think for might be a possibility for having it somewhere relatively local to the site. This is a public display set could be made available.
Well, if I can...
all gathered in by us and then put on display.
If I can ask you to just relay that back to the case officer. Double check and send that back to the case officer. Ideally so they can include it in the note. I would expect there to be a core documents list. That was one of the housekeeping matters to discuss. Now, core documents and then individual parties' lists of documents. If anyone wants to volunteer to pull together that core documents, I mean, the council have often their role, but sometimes the applicant might do that in terms of pulling together the core document list. Is there anyone particularly keen to indicate they'll take the lead? I think what I could do is record in the minute that the applicant and the council would work together on a core document list and share that with the parties, and that individual parties can obviously then prepare their own lists over and above that. The key thing is sharing the information, not just the documents but hearing statements, and ensure that all parties are circulated with any of the documents, and that our case officer is circulated with all the documents, and that will keep everyone up to date, and probably should ensure that no one would need any documents at the hearing. But it is normal sort of, or has been normal procedure, unless there's an exception for the council to take a set of all the documents to the hearing. But the key thing would be to make sure that everyone is circulated, so that all the petitioners have those documents.
Unless you're thinking otherwise, it would just be, we'll have the physical core set that's on display and be uplifted and brought to the hearing of the set that's been on public display up until that point to the hearing. And otherwise, unless there's plans or other documents that make sense to be physical, then everything else would hope be able to be digital on the day for parties.
I'll capture that in the note. So that's one sort of housekeeping matter in terms of gathering together the documentation. Are we all happy with that? The appellant and the council will work on a core documents list, and each individual party will then have their own list to be submitted along with the hearing statements. I think is normal procedure in terms of the timescales. That would be ideal if they were submitted all together. Okay, again I'll capture that in my note. In terms of a location for the hearing, the case officer and the council work together to choose this venue. Are we all happy with this venue for the hearing? Yes? Okay.
Are there larger rooms than this one in this venue? I suppose it's just if you end up with Transport Scotland as an additional party. I'm not sure. It's also, we've already mentioned. I suppose collectively the parties may have a few more people here than they do today for the respective teams for some of the sessions.
So if there's a broad agreement, it's subject to a larger room. Yep. Okay. And in terms of the programme, in terms of running order for the hearings, policy first, transport then conditions, have been set out in the appendix in that order. Is everyone happy with that order? That we deal with them in that order? It seems sensible to do that.
Yes, that would seem logical, yeah.
The first day start at a 10 o'clock start, that would be the Tuesday for the policy hearing. And just to build in a little bit of overrun there, if we don't schedule anything else that day, just in case it goes beyond and into the afternoon, but I would certainly look to close at 4 o'clock. Again, does that sound reasonable? And not to programme in the start of the second hearing, at 3 o'clock or 3:30 in the afternoon. I think if everyone's agreed to policy hearing 10 o'clock, which might include breaking for lunch and coming back, depends on how things go on the first day. Second day, usually start a little bit earlier, 9:30, so that would be the Wednesday, and closing at 4 again. And that's in relation to session 2. The third day starting again at 9:30, and continuing the transport hearing or starting with the conditions hearing. Does that sound reasonable? And if we've scheduled the whole day, then we can complete the transport hearing and then continue on to the conditions and legal agreement. Does that all sound sensible for that 3 days? And it allows a little bit of contingency on the policy and on the transport side of things. Now, I think we've cleared off and discussed access to hearing documents.
Very briefly on the timing. So on the Wednesday, would that just be a case of running until you see fit in terms of time on that day? In terms of trying to, I'm just slightly conscious if we're only starting that main topic that morning, if we're ending up running for a day and a half and just struggling to get conditions finished the following day.
I'm happy to sit till 6 o'clock on the Wednesday, but it's I think people generally tend to get a little bit tired towards the end of the day. So I'm just trying to build in anticipated completion at 4 o'clock, allows everyone to have a rest and be fresh for the morning. But will not be fixed by these are the indications. If we start a subject and we're all really keen to get that subject area cleared off by 4:30 or 4:45, then we will do that with everyone's agreement. And in my agenda, I'll set out breaks and lunch breaks and such like. We don't need to discuss those, I don't think, just now, unless there's any requirements from anyone in terms of any length of time for lunch, just a normal period of time. As I said, I think we've probably discussed access to hearing documents and core documents, and the Council have indicated that they'll get back to the case officer on the location of the case documents and bring along those documents to the hearing. Is there anything else on access to documents and hearing documents? Everyone's agreed to share all the documentations with all the parties. Is there anything else on the venue or any housekeeping matters that you want to discuss just now? Okay. Site inspection, I think it was mentioned earlier on, that's item 12. At the moment, my assessment is to visit the places I need to visit on my own. It would seem that most places are publicly accessible. At the moment, unless you advise me otherwise, I would plan site visits to be unaccompanied. I'm quite happy to hear why you would wish any site visits to be accompanied. In advance of the hearing, I will have completed all of my site inspection work, if you like. I've already had a look at things that I wanted to look at initially, but I'm happy to hear your views on the need for accompanied site visits and any reasoning around that. Applicant, first of all.
Thank you, sir. We don't see any need for an accompanied site visit, quite content with the unaccompanied.
And from SEPA's point of view?
Yes.
Yeah.
Same here. No need for an accompanied site visit, sir.
Yeah, we're in agreement that there's no need for an accompanied site visit, sir. I think the only issue when we discussed this before this meeting was really whether there was any merit from the parties just being able to submit to you of points of interest or points around it. It's not so much the site itself, as clearly you're looking at impacts on the surrounding area and whether it's helpful to almost have a list. There's clearly you can add to that, but in terms of what the respective parties' positions are on that, so that you can ensure that you've visited all of that for your knowledge.
Applicant.
Perfectly happy if the council maybe wanted to do a draft and then the rest of us could comment.
From the airport's perspective?
That's fine, sir. We'd buy into that process.
Yeah.
Did that as part of that written procedure. There's 2 deadlines in January, and that would allow that to take place.
It could perform a useful role in a double check. I'm fairly confident I'll be able to identify all the areas, but it will be a useful reference. And given it's agreed by all parties, I don't want to interfere with that. So that the suggestion is that you would collectively. I'm unsure about having that as further written information, sort of formal procedure, but I'll capture it in the note that by that time you will have provided, the council will have provided, in consultation with all the parties, a list of places of interest. Everyone happy with that? Thank you very much. Now, item 13 is just a number of fairly minor matters in terms of our website. The plan is that the website will be kept up to date with all the documents. It will also host the webcasting, not just from today, but the plan would be to webcast all the hearings. The note of the meeting, as indicated earlier on, I would like to get that out to all the parties early next week, certainly by the middle of next week, taking on board all of the matters that we've discussed. It'll be an important reference point for everyone. It'll be sent to all the parties here today that are on that list that I will certainly pick up towards the end, and have indicated their desire to be involved. I know that one party, one member of the public who has made representations has indicated that they may wish to take part in the hearing but wasn't able to arrive here today. So the note will be circulated to all the parties. It will include not just the procedures but a clear indication of the timetable, probably in an appendix, which clearly states the agreed timetable. It's a tight timetable. You will be aware that there's a target to report to ministers. I think it's towards the end of March. Now that's a tall order, but I think we should make every effort to try to be as close to that deadline as possible for everyone's interests. And once you get the note of the meeting, double check it includes everything that you're expecting in it, and crack on with whatever's in there for you. The key thing is sticking to those deadlines that we've agreed today. If we do, then the hearings can take place at the end of February, and with a fair when we should be able to report back to ministers within a couple of months after that. I don't think there'll be anyone around the table that wants further delay because we miss a couple of deadlines that we've all agreed. So. Are there any other matters that any of the parties around the table would like to raise for today's meeting? Council, anything in particular?
No, sir.
The airport?
None, sir.
None,
sir.
Okay. Thank you for your assistance today. I hope you've all been good boys and girls this year, and Santa will all be very good to you. And you enjoy the festive time and some time off. And I'll formally close the meeting and hopefully see you in February. Thank you.